Okay, ladies and gentlemen, we might get things underway. My name is Jason Beddles from the Worrells Queensland office, and you should be able to see on your screen our presenter, Matthew Jess from the Worrells Victoria office. Thank you very, very much for coming along to our presentation of asset exposure in insolvency. We've got a great turnout, so thank you all for your support and your continued support over the years. This presentation is also supported by a brochure that we produced on asset exposure. Copies should have been sent out to your offices, but if you haven't got any or you would like some more, please feel free. I'm getting some mixed messages now as to whether we've actually started the presentation or not. So I could just get, we'll just get over some technical difficulties. And then we can get things underway. Righty-ho, we seem to be underway. So thank you for those that have just joined us now. We're obviously talking today for a webinar about asset exposure in insolvency. Thank you very much for coming along. I was just talking about a brochure that we produced in respect of the asset exposure. Copies should have been sent out to you, but if you haven't received copies or you would like more copies, please get in contact with your local Worrells office and we can get some extra out to you. Before we get Matthew Jess underway, there's just a couple of administration things that we need to go through. So on your right-hand side, apparently, there is a little menu box, and in there, there's options to ask questions or chats. You can use the chat or the questions. We will get both and we'll endeavour to deal with those probably at the end of the session, unless they're rather quick, in which case Matthew will try and slide them into the presentation as he goes along. Midway through the presentation, there'll be a survey, which you'll see in that menu box on the right-hand side. It's going to take about 30 seconds to answer. It'd be really appreciated if you could do that at some point during or after, immediately after the session. It's just some questions that we've got about what you would type into Google if you're in financial trouble and looking for some assistance. If at any time during the presentation you have some problems, we need to isolate whether that's your machine or whether that's our end. So if you could start by, in those circumstances, logging out and logging back in. If you've still got problems once you log back in, then quickly jump into the chat or the questions section and we can sort of go from there. If we've got enough people complaining, then it obviously must be our end from there. Okay, without further ado, I'll hand you over to Matthew Jess from our Worrells Victoria office, who's going to launch into the presentation. Over to you, Matthew.
Thank you, Jason, for the introduction, and good morning to everyone who is attending. It's my pleasure to be presenting to you today on asset exposure in insolvency. Now, as always, I'll start with our disclaimer. It's just important to remember that the content we're presenting today is for general information purposes only. We are, of course, very happy to provide some tailored advice specific to your client's circumstances. So if that is of interest, please feel free to reach out after the presentation to your local Worrells partner, and we'd be more than happy to assist. So today we'll be running through or starting with looking at the current insolvency landscape and insolvency drivers in particular, touching on what the ATO is up to, and looking through the lens of asset exposure from our perspective as insolvency practitioners and what we're seeing. We'll consider the many limitations to the corporate veil, some of the tools that are available to liquidators and bankruptcy trustees to disrupt those clever asset protection strategies that you put in place for your clients. And applying some of those tools in practice, we'll review some recent case law developments. So first, here's a quick rundown of what's happening in the wonderful world of insolvency. Right, we haven't seen the tsunami of insolvencies that had been predicted during COVID, when ironically what we in fact saw was insolvencies falling to almost historic lows. And here in this graph, you can see that insolvency appointments have now largely normalised back to and starting to exceed pre-pandemic levels. And that's a trend that we expect is going to continue as the backlog of insolvencies that was created during COVID starts to work its way through the system over the coming years. Now, that's not necessarily a bad thing. I know you read about or see the headlines in the press about the increase in insolvency activity, but what we did see during COVID was all of that support was, quite rightly assisting businesses that would have otherwise been viable survive that period of time. And however, at the same time, it also supported a lot of unviable businesses, and it kept them artificially afloat with that COVID support. And that support was never going to make insolvent businesses solvent again, but it was certainly enough to at least delay the inevitable. So we're now starting to see time catch up with those businesses. And as these loss-making, inefficient businesses are closing down or are closed down, it'll allow the recycling of capital to more viable businesses, which will assist to drive productivity and innovation. Now, as I'm sure you're all aware, the ATO took a bit of a break on recovery activity during the pandemic, and a lot of their collection staff were redeployed to sending out stimulus checks. This graph puts that break into perspective. So in this chart, we see that bankruptcy and winding up applications are returning to pre-COVID norms, and we expect these will, in fact, start exceeding those levels. And the ATO is often the first creditor not paid when cash flow becomes tight, and they're the main driver of insolvency activity. And that's not necessarily through filing bankruptcy and winding up proceedings to recover the unpaid taxes, but it's also through all of the other collection activity that they engage in. We're talking about things like garnishee notices, director penalty notices, and reporting of tax debt to credit bureaus. And we've certainly seen the ATO is now getting serious about collecting outstanding obligations. They were in the press last week talking about how much debt levels have increased since COVID, during COVID, and their concern about there being a culture developing in particularly small business of not paying taxes. So they're certainly changing their strategy and tact in terms of recovering some of those unpaid taxes. And that's pretty understandable when you consider the ATO debt book has increased from $45.4 billion to $66.6 billion over the period 30 June 2019 to 30 June 2022. Now, a couple of points to highlight from this graph. Almost all of the growth of that debt book is classified, theoretically at least, as collectible debt, which is the blue line second from the top. Insolvency debt, and that's debt that's subject to some form of formal insolvency, has effectively remained static over the same period, which is the purple line towards the bottom of the graph. And what we do expect to see is that a portion of that collectible debt will be reclassified into insolvency debt going forward as these delinquent taxpayers enter into bankruptcy or liquidation. All right, well, moving on to part 2 of today's presentation, limitations to the corporate veil. And I'm sure you're all well aware that a simple line of defence to personal liability is operating through a company structure. But as you would be aware, the corporate veil offers only limited protection for company directors. Now, limitations to the corporate veil typically arise because the director has either voluntarily foregone the protections provided, for instance, by signing personal guarantees, There's legislation which provides for claims around it, such as director personal liability for unpaid tax and super, or by the director's own conduct. For example, could be a director loan account or a breach of fiduciary duties. Now, you'll be aware of a lot of the risks that are shown on this slide. So I'm just going to focus on a few of the common issues that we see from our perspective. Firstly, dealing with insolvent trading, directors have a positive duty to prevent a company incurring a debt whilst insolvent. Now, a claim can be pursued by a liquidator, of course. A creditor can pursue a claim for insolvent trading in their own right, or ASIC can bring a claim against the director. And the claim can be quantified by debts that were incurred whilst insolvent in the 6 years prior to the beginning of the liquidation. Now, this section applies if a person was a director at the time the debt was incurred, and that also includes shadow directors or de facto directors, and the company was insolvent or became insolvent at the time of incurring that debt, and there were reasonable grounds for suspecting the company was insolvent or would become insolvent. So it's applying that reasonable person test of what a reasonable person in the director's circumstances should have suspected. Now, the ultimate decision maker for insolvent trading isn't the liquidator or even ASIC, it's that of the court. Something that is often overlooked from an asset protection planning perspective is that holding companies are also at risk of a claim for insolvent trading of its subsidiary. And that means that the protection which can be achieved by separating assets from the trading subsidiary can be eroded in the event of the liquidation of the subsidiary. Now, in the main, the consequences for breaching the duty to not trade whilst insolvent are compensation orders equal to the debts incurred, and also director banning orders for a period of time. In the worst cases, criminal sanctions may also apply where it's proven the incurring of the debt was reckless or dishonest. The Corporations Act does provide for some defences that are available to directors for to insolvent trading. I don't have time to run through all of those defences in today's presentation, but just wanted to consider a couple of cases where some of those defences were tested. The first two that are shown on the slide, which are around having reasonable grounds to expect that the company was solvent when the debt was incurred. And secondly, relying on a competent person to provide adequate information about the company's solvency and forming a view on solvency on that basis. So firstly, in the case of Morley and statewide tobacco services, this is a case where Mr. and Mrs. Morley were directors of the company. Mr. Morley passed away. Mrs. Morley stayed on as a sole director and was sued by the main creditor when the company went into liquidation for allowing the company to trade whilst insolvent. And Mrs. Morley, since her husband passed, was a passive director. She didn't have any active involvement in the running of the company, and she left that responsibility to her son, who wasn't appointed as a director. There were two basic issues in this case. Firstly, whether Mrs. Morley, who had allowed her son to run the business while she took a passive role, could mount a defence on the basis that the debt was incurred without her express or implied consent. And secondly, whether Mrs. Morley had reasonable cause to expect the company was solvent and could pay its debts as and when they fell due. And this ultimately came down to whether she could rely on her own failure to become acquainted with the facts, which would have revealed to her the true state of the company's financial position. Now, the Supreme Court held that neither of those defences was available, and Mrs. Morley was found liable for insolvent trading. Damages were awarded against her. Now, the takeaway here is it's not good enough to say that despite being a director, that you weren't involved in the running of the company and responsible for incurring the debt. And secondly, that you didn't take steps to properly inform yourself of the financial position of the company to form a view on its solvency. Now, the next case I want to look at is in Rest His Soul, John Elliott and Waterwill Holdings. And here the court considered the defence around relying on a competent person to provide adequate information about the company's solvency. The courts have held that this defence is really specific to larger corporations with bulky accounts where there's a system in place or a structure in place of an accounting team, credit controllers, financial management, etc., that's reporting through to the board. So it's not really a defence that's going to apply for a lot of small businesses without that sort of structure in place. But even then, in proceedings brought against Elliott, with this type of financial reporting structure established, it was found that Elliott, having been provided with the company's financial statements, failed to make proper inquiry regarding the recoverability of assets and, in particular, the trade debtors. And the outcome in this case was the court found that Elliott was liable for insolvent trading and he was ordered to pay damages of $1.4 million. So this case highlights that directors need to ensure they're across the company's financial position. They need to question the information that's presented to them and understand it. Otherwise, the defence is seeking to rely on someone else is at risk of failing. Now, I just want to consider some defences that might help to mitigate the risk of insolvent trading. Now, obviously, there's concerns to solvency. The first strategy is don't incur debt. Trading COD means no debt's incurred and there can't be a claim in the event of the business failing. But practically speaking, for businesses experiencing cash flow issues, that's not always going to be a practical option. So what else can directors do? Firstly, ASIC have released a regulatory guide titled Duty to Prevent Insolvent Trading. It's a really good publication and it gives directors guidance to help them understand what they need to do to comply with their duty. Regulatory Guide 217 highlights 4 key principles which will help directors discharge that duty. And the premise of these principles is really based around making sure that they keep informed of the company's financial position. If they do have concerns about financial viability, that they immediately take positive steps to confirm the position. Thirdly, that they obtain advice on solvency and available options. And fourthly, and most importantly, acting on that advice in a timely manner. Now, where a director follows those key principles and has a reasonable expectation that the company is solvent and will remain solvent, they're more likely to be able to demonstrate that they took reasonable steps to comply with their duty. So in terms of satisfying what a reasonable person in the director's circumstances should have suspected, acting in that manner will certainly assist the directors in running that defence. Now, another strategy is the use of the safe harbour provisions. The safe harbour provides directors with an exemption from insolvent trading where they're developing a course of action which is reasonably likely to lead to a better outcome for the company and its creditors than the immediate appointment of an administrator or liquidator to the company. Now, the better outcome test could involve, as an example, a company that's facing solvency issues but has an opportunity to explore obtaining external financing that will help solve that problem. Now, the directors who might otherwise be concerned of continuing to incur debt while that option is explored could access safe harbour, and that would protect them from personal liability for debts incurred whilst that is explored. Other examples might be pursuing a sale process or completing a project that might not otherwise be completed. Now, as you would expect, the person seeking to rely on safe harbour bears the evidential burden, and there are also some qualification criteria, which include that proper books and records need to be maintained. The company needs to ensure that employee entitlements have been paid throughout the process. All tax reporting needs to be kept up to date, and advice needs to be obtained from an appropriately qualified restructuring advisor. Now, that restructuring advisor doesn't have to be a registered liquidator. It certainly can be, but you also find that turnaround specialists or solicitors might work either individually or collaboratively to guide directors through the safe harbour process. Now, it's important when going through a safe harbour that the position is regularly reviewed in case circumstances change. It's certainly not a set and forget process. And that's to ensure that the company maintains compliance with the qualifying criteria, and also that the assessment of working towards a better outcome hasn't changed. So with the example I gave of obtaining finance, if the finance is taken off the table, then the better outcome test may no longer be satisfied and the protection would fall away at that point in time. Some other strategies under the Corporations Act would be the use of the restructuring processes that are available with voluntary administration or small business restructuring. So insolvent trading can only be pursued by a liquidator. If the company can restructure through one of those processes, then it won't go into liquidation and the risk of insolvent trading falls away. Or alternatively, looking at putting the company into liquidation, whilst that will mean that the option of insolvent trading is on the table, if it's done early enough, it could certainly mitigate or eliminate that risk. Now, moving on to the director penalty regime, where the ATO pierces the corporate veil through legislation. Now, under the director penalty regime, company directors are legally made responsible for unpaid PAYG withholding, GST, and GST is only from the 1st of April 2020 forward, and also superannuation obligations. Now, I suspect at some stage, most of you will have advised a client who's been on the receiving end of a director penalty notice from the ATO. And how it works is that if a company fails to pay its PAYG, GST or super by the due date for payment, directors are personally liable for the amount that should have been paid. And that personal liability is imposed automatically by operation of law. Now, I'd just like to reflect on that point for a moment, because there's a lot of commentary about a director penalty notice or DPN being the trigger that imposes personal liability on a director. And that's not the case. The DPN has nothing to do with making a director personally liable. In fact, by the time the DPN is issued, the director's typically been liable, if not for months, more likely it's been years that's been the case. The director penalty notice itself is still a very important document. It serves two main purposes. Firstly, the Commissioner of Taxation must not commence proceedings to recover a director penalty until 21 days after a DPN has been issued. And secondly, in limited circumstances, directors can extinguish their personal liability for director penalties by putting the company into external administration within 21 days of a DPN being issued. Now, there are two types of director penalties that can apply. The first is non-lockdown director penalties, and the second is lockdown director penalties. And they derive their name by reference to whether the company has reported the debt to the ATO within set timeframes imposed under the legislation. And those timeframes are different for super and PAYG and GST. Firstly, if we look at PAYG and GST, it's within 3 months of the due date that the debt needs to be reported to the ATO. So you can be up to 3 months late. And for superannuation, it is by lodgement day of the SGC return, and that's 1 month and 28 days from the end of a quarter. So if we deal firstly with non-lockdown director penalties, these apply where directors have made their lodgements within those prescribed timeframes that I've just mentioned, but the debt hasn't been paid. So in those circumstances, if the ATO issues a DPN, the director can extinguish their personal liability if they put the company into external administration within 21 days. If no action is taken within 21 days, the director penalty permanently locks down and the ATO can commence recovery action against the director. With lockdown director penalties, they're imposed on directors where the company has failed to lodge or report the liability within the prescribed timeframes that are shown on the slide. And in this case, the penalty permanently locks down on the director. And while the Commissioner of Taxation still needs to issue a DPN and wait 21 days before they can pursue the director personally, placing the company into external administration will not relieve the director from personal liability. And to put this in perspective, we've certainly seen examples, including recent examples, of the ATO issuing DPNs for companies that have already been placed into liquidation, and sometimes it's going back 5 or more years. So the message is pretty clear. To mitigate their risk, ensure your clients keep their reporting obligations up to date, even if they can't necessarily pay the debt, as at least that will give them an opportunity to extinguish or remit their personal liability. Now, staying with the director penalty regime, an area that's perhaps flies a little bit under the radar is around newly appointed directors. Now, the way this works is if someone's been appointed as a new director of an existing company, 30 days after their appointment, they become personally liable for any historical PAYG, GST, and superannuation liabilities. And to make it worse, that personal liability is imposed whether or not that person remains as a director at the end of 30 days. So they could be appointed for 24 hours and have resigned. At the end of the 30 days, they will still be personally liable for all of the company's director penalties historically. Now, the director penalties will permanently lock down on the new director if they remain unpaid and unreported within 3 months after the date of their appointment. So some pretty nasty provisions in terms of how they impact newly appointed directors. Certainly something to keep at the front of your mind when advising clients who are considering taking on directorships in existing companies. Firstly, whether that's a risk that they really want to take on. And that's, I think, the first question. If so, conducting some due diligence around ATO arrears and the company's lodgement history would be advisable before they are appointed as a director. And once appointed, new directors obviously want to ensure they put necessary processes in place to ensure the company complies with its reporting obligations and preferably payment obligations going forward. Now, staying with the theme of the ATO for the moment, I just want to spend a couple of minutes talking about another exposure for directors. And unfortunately, the news doesn't get a lot better when it comes to director personal liability in the ATO. And many directors are unaware of a particularly nasty little provision tucked away in the Corporations Act, section 588 FGA, and which is referred to as director indemnity provisions. And in layman terms, if the court makes an order requiring the Commissioner of Taxation to repay a preference payment to a liquidator, the Commissioner can make a claim against the directors for loss or damage resulting from the order, and that includes costs and interests. And this is certainly something to consider when negotiating payment arrangements with the ATO. We regularly see companies end up in liquidation which have been the subject of multiple failed payment arrangements, and quite often with debts to the ATO in the hundreds of thousands of dollars and sometimes higher. And a lot of the times these are small businesses that realistically have no prospect of repaying the debt. And the directors have unwittingly exposed themselves to personal liability under these provisions. Now, my point here is that while the ATO may be all too willing to agree to a payment plan, directors shouldn't always frame the proposition of how little can I pay over how long, because if the business is doomed to fail, then entering to a payment arrangement simply to buy time could actually result in a worse outcome for directors if the company later goes into liquidation. And given the risk of personal liability, it may be time for a broader discussion about budgeting, forecasts, and viability of the business generally, which might involve consideration of other options such as external administration, including the restructuring options with small business restructuring and voluntary administration and deed of company arrangement. Now, these processes can be used to return the company to a position of insolvency and alleviate the risk of a director being personally liable under Section 588 FGA, as well as for insolvent trading, if the company is ultimately to end up in liquidation. Now, in particular, we've helped achieve some great outcomes for directors using the small business restructuring process. If you recall, this process came in during COVID to help businesses navigate their way out the other side. It's not limited to COVID impacted businesses, however, and it's a debtor in possession model. It allows directors to retain control and continue trading while a deal is put forward to creditors. It's cost effective. It gives them directors certainty in that the fee is payable upfront. And the ATO has shown to be very supportive of restructuring proposals. And there's some recent data published by ASIC, which noted that the ATO was a creditor in approximately 90% of small business restructuring appointments, and the major creditor in 80% of those appointments. So in terms of where these provisions have found their relevance, mostly it's in terms of doing deals with the ATO based on those statistics. And approximately 90% of restructuring plans that had been proposed had been accepted by creditors, which is a pretty incredible result. And the median contributions under those restructuring plans was 20 cents in the dollar. So there's a fair compromise that can be made to ATO debt and other creditor debt using small business restructuring that can be quite cost effective. Now, there are some qualifying criteria for that process. Debts need to be less than $1 million. Superannuation needs to be up to date, as do lodgements need to be in order. If you would like some assistance working through those options with your clients or other formal insolvency processes, then please feel free to reach out to your local Worrells partner. We'd be more than happy to assist. Now, turning very quickly to personal guarantees, I'll just fly through this. I'm sure everyone would love to avoid them, but particularly for small to medium business, that's not always realistic. A couple of tips in terms of mitigating exposure under personal guarantees. If you can't negotiate them away altogether, it's in your client's interest to do their best to negotiate limits on personal guarantees. And that's limits both in time they will operate and also a cap on value. Only recently, I'm dealing with a liquidation where the director had successfully negotiated a 2-year limit for the operation of a personal guarantee, which had been given under a long-term lease to a major shopping centre. And when he saw me for the liquidation of his company, he was understandably pretty chuffed with his negotiation skills, given he was 3.5 years into an 8-year lease and had managed to negotiate away a pretty significant personal exposure. So it's certainly something to keep in mind. Secondly, consider taking out personal guarantee insurance, and this we have insurances for all types of business risks. With this particular type of insurance, it's to cover exposure under personal guarantees. It's a relatively new product in the Australian market. If you Google it, I'm sure you'll find who's currently providing it. But it has been available in international markets for some time, and may be a useful tool for your clients to protect their hard-earned wealth. And thirdly, having some good corporate governance and maintaining a register of personal guarantees that are given as together with a copy of the guarantee. If the worst case does play out and directors have an exposure there, it will certainly assist them to understand what the extent of that risk is. All right, next we have loan accounts, and I'll start firstly with debit loan accounts, and I'm sure you see this quite often with your clients or from time to time, where they'll withdraw funds from the company's bank account, may treat the company's funds as their own to fund personal and lifestyle expenses. The issue is that when drawings are taken out of the company, it's booked to a loan account, which is recorded on the balance sheet as an asset of the company. And when the company goes into liquidation, one of the first things the liquidator will do is call up the balance of the loan by issuing a letter of demand asking that that loan be repaid. Now, there are some mitigation strategies around debit loans. Some of the examples that we can suggest is to avoid the problem in the first instance. That's always the best strategy. That involves really having good corporate discipline in place in the way the director is running the company, ensuring there is a separation of personal and business, and also ensuring that the company is paying the director a salary and deducting PAYG, so that the payments that are made to the director are recorded as an expense and not booked to a loan account. Now, understanding that that's not always, despite your best efforts in talking to your clients, not always going to be the case. If when you find out there is a debit loan account on the balance sheet, ensuring that the company is declaring a dividend on a regular basis to flush it out would be a good practice to get into. Obviously, ensuring that there's compliance with the relevant requirements under the Corporations Act. Now, with loan accounts going the other way, where we see directors and related parties who they'll commonly inject money into the company for to start it up or for working capital purposes at different points in time as the company is trading and is in need of funds. Something that's probably far less common than the advance of funds is these related parties obtaining a security interest for the loans that they do advance. Now, there's nothing to stop related parties from attaining some level of protection as a legitimate secured creditor. Of course, they need to make sure the loans are properly documented in writing with a charging clause, and that security interest is registered on the Personal Property Securities Register. This will mitigate the related parties' exposure if the company ends up in financial distress, as they'll have security over the assets of the company. Now, as practically speaking, if there is a non-related secured creditor, such as a financing bank, they'll want to have first priority. So any security interest would typically sit behind an external party. But I think that something is certainly better than nothing. And being a secured creditor may also offer some protection against the liquidator clawing back preference payments if the loan has been repaid in the lead up to a liquidation, as these sorts of claims can only be made against unsecured creditors. Now, in a perfect world, the security would be in place before any advances have been made, but understanding you'll often find out after the event, it certainly still warrants proper consideration as to whether it's worth putting those arrangements in place. Bear in mind, however, that there's a risk that a security can be set aside by a liquidator if it's put in place after the event to secure past consideration. And a liquidator can go back up to 4 years prior to a liquidation where it involves a related party. All right, now we'll just skip through very quickly, just touch on creditor defeating disposition. These provisions came into effect in February 2020 and are really aimed at assisting liquidators to recover assets that have been transferred for less than market value in the lead up to a liquidation and squarely targeting illegal Phoenix activity. Now, in essence, it involves a disposition or disposal of property for less than market value or the best price reasonably obtainable in the 12 months prior to a liquidation that prevents, hinders, or significantly delays that property being available for the benefit of creditors. Now, both the courts and ASIC have the power to make orders undoing the effect of avoidable creditor defeating disposition, which would mean that asset can be then returned to the company and the proceeds available to pay a dividend to creditors. And the legislation also allows for civil and criminal penalty provisions against company officers that fail to prevent the company from making a creditor defeating disposition, and also other persons who facilitate one of these transactions. And it's perhaps that last point that might hit home for those of you listening today, as the explanatory memorandum takes aim at transactions facilitated by not only pre-insolvency advisors, but also accountants and solicitors who might be assisting their clients with a restructure. So if you're practicing in this area, these provisions are something that you certainly want to be aware of and fully across in terms of just understanding your own risk profile. Now, we've discussed some of the risks directors are personally exposed to, and when a director faces personal liability for company debts which they're unable to pay, ultimately it can lead to them being declared bankrupt. Now, in terms of assets a trustee in bankruptcy has access to, it's pretty much everything of value. Even after acquired property will vest up until the bankrupt's discharged from bankruptcy, which means things like inheritance or a tax lotto win could be available to creditors of the bankrupt estate. Now, some property is exempt as shown on the slide, and this includes superannuation in a regulated fund at the date of bankruptcy. And not only does a trustee have access to assets of a bankrupt, they also have access to their income above a certain level. A bankruptcy trustee also has powers to disrupt and undo asset protection strategies which are put in place, especially those strategies are not set up correctly, or more commonly, where they're set up at the last minute. So let's look into some of these, and some of the common weapons available to a trustee in bankruptcy to disrupt asset protection strategies are shown on the slide, dealing with undervalued transactions, transfers to defeat creditors, and where assets or wealth have been accumulated in the name of an entity or other person. Now, firstly, dealing with Section 120, undervalued transactions. Essentially, these provisions provide that a transfer of property is void if it's for less than market value and the property was transferred where it's to a non-related party within 2 years of the commencement of bankruptcy, and for related parties within 4 years of the commencement of bankruptcy. So the bankrupt could well have been solvent at the time of the transfer. If it's less than market value, it will still be void within those timeframes under those provisions. If the bankrupt was insolvent at the time of transfer, those timeframes can be extended out to a maximum 5-year period from the commencement of bankruptcy. The other main provision is Section 121, transfers to defeat creditors. Now here, a transfer for less than market value will be void against the trustee, where the relevant property would probably have become part of the bankrupt's estate or would probably have been available to creditors if it had not been transferred. And the bankrupt's main purpose in making the transfer was to prevent, hinder, or delay that property being available to creditors. So effectively what that's saying is if the transfer was to defeat the interests of creditors. Now, whereas we had a 5-year time limit that applied for undervalued transactions, there's no time limit on how far back a trustee can go under these provisions. And separate to Section 120 and 121, if the trustee in bankruptcy can show the bankrupt has made a financial contribution in respect of property owned by a third party, and the bankrupt has derived a benefit from that property, the provisions in Division 4A of the Bankruptcy Act allow a trustee to make a claim to an interest in that property. So these provisions are really targeting where wealth or assets have been accumulated in the name of another person or entity in the period leading up to bankruptcy. And typically it might involve where income of the bankrupt is channeled to a family member, such as a spouse, or they've provided services to a family trust or other structure which is controlled by the bankrupt for inadequate consideration. Now, with the provisions under Division 4A, there's a 5-year time limit that applies, and the elements to be satisfied differ depending on whether the trustee is bringing a claim against an entity or a natural person. Now, where it involves an entity, it's limited to a relatively specific set of facts, which is comprised of 6 elements, as shown on the slide, and all of those elements must be met. And that includes the bankrupt having provided services to the entity for no or less than reasonable remuneration, and the entity acquiring property due to those services, and the bankrupt deriving a benefit from the property. Now, these provisions have only been the subject of a handful of decisions, which perhaps highlights the difficulty of satisfying each of the 6 elements. But where a trustee can successfully prove them, the court may order that the controlled property or a percentage of it vests in the trustee in bankruptcy. Or alternatively, the court may order that the entity pay the trustee an amount that represents the increase in the net worth of the value of the entity as a result of the services that have been provided by the bankrupt. Now, similar forms of relief are available where the entity is a natural person, and where it involves a natural person, the requirements are less onerous and they don't include the control requirement. They speak of direct or indirect financial contributions made by the bankrupt rather than services provided, and there's no requirement relating to remuneration. Now, I touched on superannuation earlier as being an exempt asset, so not available to be realised by a trustee in bankruptcy. However, there is a caveat to that. A trustee in bankruptcy is able, or there are provisions that allow a trustee to claw back contributions into a super fund that are made in the lead up to bankruptcy. The provisions are quite similar to transfers to defeat creditors under section 121, and the trustee needs to show the property probably would have become part of the bankrupt the estate and available for creditors, and the main purpose in making the transfer was to defeat the interests of creditors. Now, when we're talking about that, practically speaking, what a trustee would be looking at, or the court would be considering, is the historical pattern of contributions into the super fund. So a one-off contribution when an individual's on notice of insolvency is much more likely to be able to be clawed back under these provisions, as opposed to a circumstance where there's been a historical pattern of contributions on the 30th of June each year to put funds into superannuation for retirement purposes. Now, I want to spend some time running through some case law updates and recent case law developments, and won't have time to go through all of these cases, so we'll skip through or get through what we can. The first one is a case that you may well be familiar with, which is Bosinac and the Commissioner of Taxation. And it's not an insolvency case and doesn't fall under the umbrella of the clawback provisions available to a trustee in bankruptcy that we've just worked through, but it does clarify the position of the law as it stands with respect to resulting trusts and presumption of advancement. So I think it's worthwhile running through, and as we get to the end of the case, I just want to consider how a trustee in bankruptcy may have attacked an interest in the property, which is a little bit different to how the Commissioner of Taxation went about it. Now, the essence of the facts involve the purchase of a property in 2006 for $4.5 million. The deposit of $250,000 was paid using funds from a joint loan account, with the balance of the purchase price being borrowed jointly by Mr. and Mrs. Bosinac. And Mrs. Bosinac became the sole registered owner of the property at the time of purchase, which is a pretty common strategy where you have the financially at-risk person holding no interest in the matrimonial property, but still deriving a use or some benefit from it. Now, in April 2016, some 10 years later, the Commissioner of Taxation obtained a summary judgment against Mr. Bosinac for approximately $9.3 million plus costs. And this came about as a result of an audit where the Commissioner discovered Mr. Bosinac had failed to lodge returns for the period 2006 to 2013. The Commissioner then commenced proceedings to recover their debt and pursued a claim against Mrs. Bosinac, arguing she held a half interest in the property on trust for Mr. Bosinac. And by this time, they had separated and Mr. Bosinac had moved out of the matrimonial home. The Commissioner was seeking a declaration that 50% of the property belonged to Mr. Bosinac because a resulting trust existed over the property. And this is on the basis of contributions that he had made. And in their view, on the basis he did not intend for his wife to be the sole registered proprietor. Now, the basic premise of the presumption of resulting trust is that equity will assume people don't usually intend to make gifts of real property. And the effect of this is that the recipient is then said to hold the property on trust for the other person, unless the presumption can be rebutted on the facts, which is what Mrs. Bosignac argued. And she resisted the Commissioner's claim by asserting that the resulting trust was rebutted by the presumption of advancement. Now, with the presumption of advancement, where this applies, the property is treated as being handed over to the recipient, and they receive, or they can assume, full legal title and don't hold the property on trust for that other person. And when considering this, the court will take into account the parties' intentions around the transaction at the time it was entered into. Now, the Commissioner argued that where the parties contribute equally to the purchase of a matrimonial home, which is to be occupied and utilised by them both, that the presumption of advancement should not exist. In the first instance, the court found in favour of Mrs. Bosignac and held that the argument of the Commissioner wasn't persuasive and that the presumption of advancement would apply. Now, on appeal, the full federal court held that the presumption of advancement was rebutted by evidence of contrary intention for a variety of reasons, including that Mr. Bosignac had secured loans against the property for his own personal investments. And the question that was dealt with on appeal was, what did Mr. and Mrs. Bosignac actually intend the beneficial ownership of the property to be at the time of purchase? And essentially, it was found that it was intended that there was to be joint use and benefit from the matrimonial home. The full court declared Mrs. Bosignac to hold 50% of the property on trust for her ex-husband. Mrs. Bosignac then appealed, and we went all the way to the High Court and came full circle with the decisions, where the High Court held there was no resulting trust arising. The key reasoning of the High Court in arriving at their decision is shown on the slide, which came down to establishing the intention of the parties at the time of entering into the transaction. And that includes that Mr. Bosignac was a sophisticated businessman who understood the consequence of property being registered solely in the name of his wife, and the conduct of the Bosignacs in other transactions where historically ownership of matrimonial assets were purchased and held separately. So this wasn't anything particularly unusual. And they also had a history of debt being taken out jointly to fund those purchases and using each other's assets as security for the benefit of each other. Now, ultimately, Mrs. Bosignac's appeal was allowed on the basis that the parties had intended for her to be the sole beneficial owner of the property. Now, what's interesting is that the High Court reached their decision, no resulting trust arose on the facts, and not by establishing or applying the presumption of advancement. So the High Court has confirmed that structuring for asset protection this way can hold up, but of course, each case is going to turn on its facts. I think the takeaway is that it's important that the transaction and intentions of the parties are documented properly and contemporaneously at the time of the transaction being entered into, as that's going to best assist your clients to more easily establish intent or their intent at the time of the transaction if it becomes a point of issue or contention down the track. Now, as I mentioned, Bosignac isn't an insolvency case. I just want to now test how Mrs. Bosignac might fare against the trustee in bankruptcy and revisiting some of those tools that are available to a trustee to disrupt asset protection strategies. And firstly, before we get into that, a trustee in bankruptcy could, of course, bring a claim on the same basis that the Commissioner of Taxation did, which there wouldn't be any purpose to, given that's already been determined by the High Court. But looking to the powers that could be, or the basis of a claim that could be pursued by a trustee in bankruptcy, Firstly, we can deal with the $250,000 deposit. Now, that was paid more than 5 years prior to bankruptcy, so Section 120 dealing with undervalued transactions won't apply. It could, however, be attacked under Section 121, transfers to defeat creditors, as no time limit applies here. And the trustee would need to establish a few things, including that the bankrupt's interest in those funds would probably have been available to creditors if not for the transfer to the benefit of Mrs. Bosignac. And also that the main purpose of the transfer was to defeat the interests of creditors. So with the first question is, would the $250,000 deposit probably have been available to creditors? And as you recall in the background facts, the deposit was paid from joint borrowings. So arguably, Mr. Bosignac's share of that deposit would not have been available as it was borrowed funds. But just so we can run this exercise through, let's assume for the sake of today that the deposit had been paid from joint funds and that threshold requirement was met. The trustee would then need to deal with establishing main purpose. Now there's a subsection of Section 121 at subsection 2, which sets out that main purpose is established if at the time of transfer the person was or was about to become insolvent. Now here you recall the ATO audited Mr. Bosignac's affairs and identified he failed to lodge tax returns for the period 2006 to 2013, which led to that $9.3 million debt to the ATO. So if we look at the timing, the property was purchased in 2006. So it's going to come down to an assessment of his financial position at that time as to whether the trustee could prove insolvency. And perhaps given the timing of when that ATO debt started to accumulate, he was in fact solvent at that point in time. Now, being insolvent is only one way that main purpose can be proven. It can be established in other ways by the surrounding circumstances to establish intent. Now, if we go back to what the High Court's reasoning was here, they determined that the purchase was pretty typical of the way the Bosignacs had purchased marital assets, so there's nothing out of the ordinary. So in that sense, I think a trustee in bankruptcy may well have quite a few difficulties establishing that the main purpose was to defeat the interests of creditors, given there was a history of conducting transactions in the marriage of this nature. So the High Court had also determined that Mrs. Bosignac wasn't put up to purchasing the property in her name, which again would be in her favour. So putting all this together, I think a trustee in bankruptcy could face some challenges proving the required elements of a transfer to defeat creditors to claw back Mr. Bosignac's share of that $250,000 deposit. Now that brings us to the provisions under Division 4A, which is where assets or wealth are accumulated in the name of another person, in this case, Mrs. Bosignac. Remember, here there's a 5-year time limit that applies from the commencement of bankruptcy. Any claim would be on the basis of financial contributions that Mr. Bosignac had made to the property over this time, such as paying the mortgage, provided that he had used or derived a benefit from the property during that 5-year period. Now, it's my understanding that he had been servicing the mortgage, and on that basis, and living in the property, on that basis, I think that a trustee would likely have much better prospects of success relying on these provisions. And the claim would be for the value by which Mrs. Bosignac's interest in the property had increased over that 5-year period. Now, you'd appreciate the quantum of that sort of claim would likely be far less than the 50% interest that had been pursued by the Commissioner of Taxation under the resulting trust claim. But I do think it's useful to consider the Bosignac decision in this slide. It does highlight the different basis of making a claim between a normal litigant and a trustee in bankruptcy. Now, we're fast running out of time, so I won't talk to this next case. It was a matter in which I was a trustee in bankruptcy. I was the trustee in bankruptcy together with Paul Benness in my office, where we were successful in obtaining orders under Division 4A of the Bankruptcy Act quite recently to have a a property which had been purchased in the name of the bankrupt's daughter, transferred into the benefit of the bankrupt estate. So the daughter's parents had used their assets to fund the purchase of the property in her name, and ultimately we were able to prove the required elements under Division 4A and void those transfers and have the property vest in the estate, which we have recently sold, and be able to use the proceeds to pay a dividend to creditors. I do want to spend a couple of minutes talking through our next case before we wrap up, which is a recent decision that was handed down in the matter of Arvanis and CAP, in the matter of the bankrupt estate of CAP. And this case concerned two claims brought by the trustees in bankruptcy. The first claim was against the bankrupt's wife under the transfer to defeat creditor provisions, involving a claim to proceeds from the sale of the former family home, which had been transferred to the spouse some years prior. And the second claim was under the Division 4A provisions in relation to wealth created in an entity, being a family trust, from services provided by the bankrupt for no remuneration. Now, the bankrupt in this case was a solicitor. He had held roles at senior partner level at different firms in Sydney over the years. And the background is that he was diagnosed with terminal cancer in 2010 and transferred his interest in the property into his spouse's name around that time. Now, ultimately, he survived the cancer diagnosis after undergoing exploratory treatment and went into remission in 2011. Now, a little bit of further background, the bankrupt had financial obligations from his first marriage and a history of not paying tax, which predated his illness. And in 2001, his tax liabilities were $293,000. And at the time of bankruptcy, they were $4.7 million. Now, ultimately, it was found against the wife that a purpose of the bankrupt's transfer to his wife was to provide for his wife and children following his terminal cancer diagnosis. But there was more than one purpose, and the main purpose that was established was to defeat the claims or interests of his creditors. The trustees, if you recall, he had a history of not paying tax, and there was an existing liability outstanding at the time that he wasn't able to meet. Now, the trustees' claim under Section 121 was successful. However, ultimately, the trustees lost as the wife successfully argued the doctrine of exoneration applied, which was on the basis that she'd paid tax debts and legal fees for the bankrupt. So effectively, the way this works is there was a secured debt, a mortgage on the property that the funds had been used solely for the benefit of the now bankrupt. So even though the trustees were successful in having an interest established in the property, the secured debt was first to be repaid from their share of the equity, which fully extinguished their interest in the property. So it goes to show that as a trustee in bankruptcy, when you win, you can sometimes lose. Now, in relation to the claim against the trust, the proceedings pursued under Division 4A, it was found that no remuneration had been received by the bankrupt, despite him having entered into consulting agreements with the trust for the provision of legal services of $500,000 and $600,000 per annum. The court was also satisfied the bankrupt had received a benefit from property owned by the trust, as he had a right to receive rental income. And the trustees were able to establish the other elements under Division 4A, those 6 elements we talked about earlier, and established a claim to successfully obtain orders vesting 35.94% of relevant property of the trust in the trustees. And by that time, the property had been sold, so it was the proceeds of sale. So a couple of interesting cases there, just to give some context to how the tools available to a trustee in bankruptcy work in practice. I won't talk to this next case. This is the first decided case on creditor defeating dispositions in telecoms. Effectively, it involved a transfer of assets immediately prior to liquidation for less than market value. The court held that the transaction had all the hallmarks of a classic illegal Phoenix transaction, and orders were made overturning the transaction, setting it aside under the creditor defeating disposition provisions. And that brings us to the end of today's presentation. We've outlined some proactive strategies to mitigate the risk of personal liability falling on directors. We've also outlined there's many tools available to insolvency practitioners, whether that's a liquidator or a bankruptcy trustee, which serve to disrupt asset protection strategies. And we're now happy to take some questions. Hopefully you've gained a bit of insight into what we see when, or what to look out for with the potential exposure faced by individuals in business.
Thanks, Matt, for all of that. We do have a couple of questions, and so I don't know if you can see them up on the screen there, but it's labelled question 2, and perhaps if you could help out about just, excuse me, anecdotally what we're seeing in terms of the secured party groups correctly complying with their requirements under the PPSR. Is there an increase in the number of challenges that administrators are making?
Yeah, I can certainly talk to that. Look, this is there's a lot of risk here for people in business around registering security interests, and there have been some cases decided over the years where not only for small business but big business where they've got this wrong and they've lost out significantly as a result through a failure to register security interests. Really, a lot of the registration on the PPSR becomes most relevant on an insolvency outside of the priority, I suppose, of security interest between competing secured parties. But it's when the company becomes insolvent that the security interest will vest if there's a problem with it or it hasn't been secured. And we are still seeing issues of that nature, absolutely. We had one quite recently involving Westpac Bank where they incorrectly recorded the security interest. We wrote back to them setting out why we considered it was invalid and vested, and they rolled over pretty quickly, recognising that they had got it wrong. So we're certainly seeing a fair bit of it still. And I'm not sure if you have anything to add to that, Jason, in terms of your experience on files recently.
I think it's just a little bit scary, isn't it, that was a company the size of Westpac is still having problems with the PPS legislation and getting it right. So if they're having problems, what chance does the smaller business have in trying to understand that legislation? So,
yeah, absolutely.
We do have another question, but it might require you to think back a little bit through the presentation, Matt, because it was obviously typed at the time that you were sort of talking about the topic. And I'm trying to get some context on it, but unfortunately I can't, because the question was, is the situation the same if payments made to a director of trust and trustee company goes into liquidation? So I'm not too sure if that related to the preference section you're talking about, or maybe you know what it might relate to.
Yeah, look, I'm not entirely sure, but I don't think there's really going to be any difference there in any event, no matter what the application. It's obviously the trust needs a trustee. If the company's a trustee, it goes into liquidation, then the voidable transaction provisions in solvent trading all apply in relation to the corporate trustee. So I think that there's really no point of distinction there being a trust involved as far as I can tell, or from my experience.
Okay. Hopefully, Tom, that answers your question. But if it didn't get quite to the point, then feel free to reach out to Matthew or I by phone or email, and we can sort of clarify it from there. And that brings to an end all of the questions that we have, and therefore to the end of our seminar. Thank you very much, everybody, for attending. I hope you enjoyed it and got some valuable information out of that. You'll receive an email in due course with your CPD certificate for today, together with a link to a recording of the presentation and the slide deck that Matthew took you through from there. As always, if you've got any insolvency queries, please feel free to reach out to anybody at any of the Worrells offices right around the country. And with that, we'll bring the session to end. Thank you very, very much, everybody, for attending. Have a great day. Thank you.
Thank you.